Hey friends, welcome back. This is class 15 of corporations class. The topic for today is our last substantive topic in the duty of loyalty, which is to cover a special rule called the business opportunity doctrine. We're also going to talk about a related set of rules that deal with protecting fiduciaries from the outside risks of fiduciary liability, and that will come under the topics of exculpation, indemnification, and insurance. So the business opportunity doctrine, let me just refresh your memory about one thing. When we first started talking about the duty of loyalty, we said that there is a basic test that applies in most duty of loyalty cases, and that is called the intrinsic fairness test. So when no other more specific rule applies to a given case in which a fiduciary has a conflict of interest, then the intrinsic fairness test applies. It turns out there are a few more specific rules. In fact, in the general law of agency, there are quite a few specific rules that govern special situations in conflict of interest scenarios. We're only going to talk about one of them, though. You learn more about the special rules in the A&P class. By the way, you may be wondering what that thing is. I made that. My kid's into D&D, and I made that for a birthday cake once. I know it's hard to believe, but that was actually a birthday cake. So how you like me now? Anyway, so the only one of these specific rules we're going to talk about is this business opportunity doctrine. And that's because it's the only one of them that's really particularly relevant to the corporate context. Again, you learn the other particular rules for conflicts of interest in the A&P class. They're interesting. None of them are too complicated or fascinating, really. All right, but the business opportunity doctrine. So this thing applies in certain special cases that we're going to learn about in a case called Braz versus Cellular Information Systems. So let's dig into that. The facts are just a little bit complicated, so I diagrammed it out, and let's take a look at the picture. Okay, so the basic facts of Braz versus Cellular Information Systems involved a challenge to the conduct of a man named Robert Braz, who was the defendant. So Braz was himself an entrepreneur in a field that at the time was relatively new in cellular telephone communications. Braz was the president and 100% shareholder of a firm that was essentially an incorporated sole proprietorship. His business, RFB Cellular. RFB Cellular apparently was doing its work mainly in Michigan, in the upper Midwest, selling cell service there. It so happened, however, that Braz also was affiliated with another cell phone business called Cellular Information Systems. Now, CIS did cell business mostly along the Atlantic seaboard in the eastern part of the country. An important fact, an important part of the facts in the case, was that Cellular Information Systems, at the time that Braz was involved, was not doing well financially. It was a suffering firm, and its business was shrinking. All right, now a key fact in the case is that there was an asset available that more than one person wanted, and this was an FCC license, federal permission to sell cellular telephone service in a particular area. Specifically, a license was available to sell cell service in northern Michigan. This thing was called the Michigan 2 license. These assets are pretty valuable because you can only sell the product with one, and there's only one license or limited numbers of licenses for particular regions. So it turns out Braz wanted this thing, other people wanted it too. An interesting fact, a fact that's important to the doctrinal rules that apply in the case and the result in the case, is that Braz didn't learn of this Michigan 2 opportunity on his own. It was brought to him by a firm that is described in the opinion as Mackinac. Mackinac was a broker, the kind of business that goes around trying to find buyers for particular things that somebody's trying to sell. So Mackinac looked up Braz as a potential buyer for this thing. And what's important is that Mackinac approached him in his personal capacity. That is, it approached him as the president and 100% shareholder of RFB Cellular, and not because of his relationship to Cellular Information Systems. So, like I said, Braz goes about and tries to get this thing. He tries to buy the Michigan 2 FCC license. Well, it so happens that as all this was going on, there was in fact another firm that was interested in the Michigan 2 FCC license, and that's a different firm, a third-party entity called Pry Cellular Incorporated. Pry Cellular is also engaged in selling cell service in various places, and it was not a suffering firm like Cellular Information Services. Pry Cellular was growing, and it wanted to expand, and Michigan 2 was desirable to it. That, however, is where things start getting just a little hairy, because it turns out that even as Braz was trying to get the Michigan 2 license, and Pry Cellular was too, Pry Cellular was in the business of trying to acquire Cellular Information Services. These two things seem to be unrelated. They just happen to occur at the same time. Now, it's important to the case that at no time after Braz's acquisition of Michigan 2 had Pry Cellular in fact acquired Cellular Information Services. Okay, so let me say that again. During the fight between Pry Cellular and Braz to acquire the Michigan 2 license, during that whole time, Pry Cellular was still just a third-party outsider that had not yet acquired Cellular Information Services. That'll turn out to be important. So anyway, there then ensued a bidding war between Pry Cellular and Braz over the Michigan 2 license. This went on for a while. There was some brinksmanship. There were competing offers and ever-increasing offers to pay higher and higher prices. Ultimately, Braz wound up getting the thing. He won the fight. Once again, this happened before Pry Cellular was able to acquire Cellular Information Services. What happened after that was that Pry Cellular, as often happens when firms acquire targets, Pry Cellular laid off all the management. So Braz and the other defendants in the case were all let go. Okay, so some pretty important stuff happened during all of this, some pretty important facts. First of all, like I said, Braz was approached with this opportunity by a broker on behalf of the owner of the Michigan 2 license, looking for a buyer in his personal capacity, not in his position as a director of Cellular Information Services. Also important was that Braz was fairly cautious once he'd been approached with this opportunity. Specifically, he spoke to the CEO of Cellular Information Services. He spoke to another director. Both of those people told him that, in fact, Cellular Information Services would not be interested in purchasing the Michigan 2 license. This was perhaps an abundance of caution for Braz to have done these things because, as we'll see in the facts, it was very unlikely that CIS would have wanted this thing. But it probably was the prudent thing to do, and indeed it didn't hurt Braz once he got sued for this. Okay, so those are the facts, and here is the legal problem. Pry Cellular is, well, let me step back just one second. So what happens to Braz once all this is over, once he's acquired the Michigan 2 license, and shortly thereafter Pry Cellular acquires Cellular Information Systems, is that Cellular Information Systems sues him, okay? And it sues him on the theory that he purchased something under a conflict of interest. He purchased the Michigan 2 license, and surely he has a pecuniary interest in that thing. He's paying his own money for an item that he wants. Cellular Information Services says he has a conflict, though, because Cellular Information Services, in fact, might have wanted that thing. Braz at least should have made it available to Cellular Information Services on some basis other than what he did. So this may seem a little odd because, as we know, Braz did do that. He did, in fact, talk to the CEO. He talked to at least one director, and they told him that they didn't want it, that CIS wouldn't want this thing. So what gives? Well, the backstory, the real action just barely beneath the surface is that once this lawsuit is filed, CIS is a very different company. CIS now is owned, it's controlled by a new parent corporation, a new controlling shareholder, which is Pry Cellular. In other words, even though nominally CIS is the plaintiff in this case, it became the plaintiff because the real party in interest is the same firm that was fighting with Braz to acquire this license before the acquisition. So what's effectively going on is that Price Cellular is suing Bras, alleging that he owed it to Price Cellular to allow Price Cellular to get its hands on this license. An important fact in the case, though, and something important for us to keep in mind, is that the lawsuit alleges a breach of a duty owed to CIS. Bras was a fiduciary, and he owed fiduciary duties to CIS because he was a director of CIS. You might ask, well, could he also in some way be a fiduciary, owe his fiduciary duties to Price Cellular, the controlling shareholder of the firm of which he was a director? And indeed, that issue came up in the opinion. The Delaware Supreme Court specifically addressed that. Price Cellular apparently litigated the issue, pressed upon the court the argument that the controlling shareholder of a firm can express interests or can hold interest that a fiduciary of that firm has to take into account in judging their own actions. But the court says, however that may be, Price Cellular, in fact, didn't acquire CIS until after Bras bought his license. This is discussed on page 606 in the second edition, the last couple of paragraphs of the opinion. The court says, it very well may be that Bras could have owed duties to consider the interests of Price Cellular had the acquisition been made before he got the license. Let's think about what that means exactly. Is the court there saying that Bras, in fact, would owe his duties to Price Cellular? And the answer is no. Bras would not owe duties directly to Price Cellular. The reason it could be relevant if Price Cellular had acquired the thing is because when there's a business opportunity, when you want to invest in something as a fiduciary that could be of interest to your the beneficiary of your duties, to the company that you work for, you have to ask, by applying the test that we're going to talk about in a second, you have to ask, well, what does that firm actually want? What sort of things might it want to buy? What does it want to invest in? That calculus will change if the firm comes under control of a new controlling shareholder. So when CIS was acquired, well, it turned from a firm that was a struggling, shrinking, declining business located on the Atlantic seaboard. It changed into part of a bigger, growing corporate family that, in fact, was expanding and did suddenly have interests in selling its services in the upper Midwest. So it could have mattered. It just didn't happen that way for Price Cellular. So the court says Bras never owed his duties to Price Cellular. So the only question in the case is whether Bras owed it to CIS, as the company existed before it was acquired, to consider the interests of CIS in purchasing this license, and if so, whether he did enough to make sure that CIS had the opportunity to buy it first. Okay, so let's just recap before we get into the test, this so-called Guth versus Loft or line of business test that we're going to figure out as the basic lesson of the Bras case. Let's just recap. In cases of conflict of interest that arise in the special circumstance in which the fiduciary wants to invest in something. Like the fiduciary isn't selling something to the corporation. The fiduciary isn't buying something from the corporation. The fiduciary is not voting on their own compensation. In other words, the fiduciary is not engaged in some transaction with the corporation or engaged in a transaction personally that somehow the corporation is a party to. Instead, the fiduciary wants to do something not directly related to the corporation, but in which the corporation itself might have some interest. That is the problem that's addressed by the business opportunity doctrine. So when you sniff a conflict of interest, but it seems to have to do with an investment in something that's not clearly a property or interest of the corporation yet, but might be, you probably have to apply the business opportunity doctrine. Okay, so to apply the test as it's formulated in Delaware, and indeed this is the majority rule, we're going to turn to the Guth versus Loft test, which appears on page 604 in the book. Now, let me say one thing. We're going to talk about a couple of different rules here. We're going to talk about the Delaware test, which is the majority test. We're also going to talk about a couple of minority rules, A couple of rules are discussed in the Harris case that we're going to talk about next, and most importantly, the new sort of clever test that exists under the American Law Institute Principles of Corporate Governance. That's what's applied by the Supreme Court of Maine in the Harris case. We're not very often going to talk about majority and minority rules in our course. It won't come up very often. But this is one of those cases. So I do actually want you to know both the Guth test and the ALI test. All right, so let's dig into the Guth test and with some diagrammatic mapping out of this thing to help us, here we go. So the Guth test is a common law test that is very, very mushy. It's a multi-factor test, but it's very much a facts and circumstances test, and no one of the many factors is necessary or more important than the others. The way the court breaks down the test is that it breaks basically into two different inquiries, and it's not very well explained, but in effect, the two different inquiries say, first, you ask, given 4 specific questions, whether an opportunity, in fact, belongs to the corporation. So the first question is, in some sense, as a matter of fairness, does an opportunity belong to the corporation? So the first question in this first inquiry is to ask whether the opportunity would have been one that the corporation could have brought in the first place. Could the corporation have invested in the thing as a matter of its own financial capacity? So I think that seems pretty simple, right? That's a pretty simple factual inquiry. It's easy to give a yes or no answer. After that, the questions start getting a little bit more squirrely. So the next question we have to ask is whether the opportunity is within the corporation's, quote, line of business. The reason I think that's a little squirrely is because the next question is whether the opportunity is within the corporation's interest or expectancy. And the problem is that it's kind of hard to distinguish these two things. A way of thinking about this is to ask which one of these two things is broader and which one is narrower. And to make that easy, I'm just going to tell you. The line of business inquiry is broader. That is, it's possible for something to be within the line of business of a company and not be within its interest or expectancy. But the reverse is not really true. If it's within the interest or expectancy of the corporation, it's very unlikely that it's not within its line of business. So line of business seems to mean something very broad, like is this in the general ballpark of the kind of work that you do? Interest or expectancy, though, means something more like a legal entitlement or some legal expectation, or at least some evidence that the firm has in fact tried to invest in something before. So, for example, if a firm has taken an option on an investment, has purchased a right of first refusal, or has taken steps to negotiate for the purchase of something, those would all be facts that demonstrate interest or expectancy. The final question in the first inquiry, would the opportunity create a conflict of interest, is pretty straightforward, much easier than questions 2 or 3. The question is really just whether investing in the opportunity would make the fiduciary a competitor of the corporation. So if CIS and RFBC, Braz's own firm, would be direct head-to-head competitors in Michigan's cell phone service after acquiring the license, that would create a conflict of interest, and the question 4 would be answered in the affirmative. Okay, well, as I said, even if you answer the first question yes, and you determine that an opportunity is one that really does belong to the corporation, you still ask some questions under the second inquiry. Specifically, you ask, and basically what we're doing here is to say, even if the answer to the question, the first question is yes, there are still considerations that can be taken into account to say that the fiduciary's choice to invest in the opportunity did not breach their fiduciary duties. The first of those questions is whether the opportunity was presented to the fiduciary in their personal capacity or in their official capacity as fiduciary. The second is whether the opportunity is essential to the corporation in some way, like losing it will be very bad for the company. The third is whether the opportunity is outside the corporation's interest or expectancy. And you might be thinking, geez, that's kind of weird. I mean, that seemed like a question you were supposed to answer yes the first time. But bear in mind, you might answer the first inquiry yes, even though your answer to question 3 was no. All right? Okay, and finally we ask, has the defendant misused a corporate resource to exploit the opportunity? So this can happen sometimes. A director or an officer might learn of some great investment opportunity by using confidential information that the corporation itself has developed, like customer lists or research into investment opportunities. And that's a serious no-no. If there's evidence of that, the odds are it was a corporate opportunity, and investing in it was a breach of fiduciary duty. But the courts are telling us that if the person didn't do that, if they learned of it on their own, well, that's a factor that weighs in favor of letting them take the opportunity. Okay, so let's ask ourselves how things look for Braz under this test. Under the first inquiry, things look pretty good for him, and the court indeed seems to believe that this really just wasn't an opportunity that belonged to CIS in the first place. So is the corporation financially able to exploit the opportunity? No, CIS was struggling. Is the opportunity within the corporation's line of business? Well, yes, broadly, it surely was. CIS is in the cell phone business. Is the opportunity within the corporation's interest or expectancy? So here, things look pretty bad for the plaintiff, Price Cellular, because not only was CIS not taking affirmative steps to try to acquire this license or things like it, CIS, in fact, was shrinking and was deliberately divesting itself of assets and was taking lots of steps that suggest that it wouldn't have any interest in expanding into a new territory. Finally, would taking the opportunity create a conflict of interest? Well, not really, because CIS did not sell competing cell service in the northern Midwest. So probably Braz is in pretty good shape even under the first inquiry. If Braz had, though, failed the first inquiry and a court were willing to say, in the absence of other considerations, this is an opportunity that belonged to the corporation and Braz should have offered it to the corporation, well, we can still ask the questions under the second inquiry. First, was the opportunity presented to the D in his personal capacity? It was personal. That's a good fact. Is the opportunity essential to the corporation? Plainly not. Is the opportunity outside the corporation's interest or expectancy? Well, yeah. And finally, did Braz misuse corporate resources to exploit the opportunity? Plainly not. So this was a good case for Braz. One final thing in applying this test to the Braz case is the discussion in the case concerning the fact that Braz did, in fact, make some disclosures to CIS and they were rejected. That is, the CIS itself, by actions of its CEO and one of its board members, told Braz that CIS did not want the opportunity. CIS was rejecting the opportunity. The Supreme Court asked the question, really only in dicta, whether that is fatal to Braz. Like, is there some obligation under Delaware law that there has to be a formal presentation of an opportunity to the board or to some other appropriate decision maker within the corporation, or else there's an automatic violation of the duty of loyalty under the Guth versus Loth test? And the court says emphatically no. In fact, for purposes of this case, the court just says, look, we'll assume that Braz just talking to the CEO and talking to a director, those don't constitute a proper presentation and rejection of the opportunity. So that in and of itself is not mandatory at all under the Delaware rule, which is the majority rule. Okay, well, that brings us to a different case, and that is the Harris case from Maine. Okay, so I like the Harris case in a lot of ways. It's fun facts. It's sort of nice to every once in a while to catch somebody doing something sort of naughty. But really what's important about the Harris case is two things. Thinking about this case is a nice opportunity to think about the problems in the Guth versus Loth test. So the business opportunity doctrine has turned out to be awfully hard to apply. It's very, very mushy. It's very subjective. Courts tend to sort of apply their own ideologies in doing these cases, and it can be hard to guess how cases are going to be decided. So reading the Harris case turns out to be a nice opportunity to think about those problems, in part because the facts of the case nicely show how the Guth versus Loth test doesn't really fit every situation very well, and also because the court ultimately adopts a new test, a special test under the American Law Institute Principles of Corporate Governance. So that thing, the Section 5.05 of the ALI Principles, has not been widely adopted. In fact, I think it's only adopted in 2 states, Maine and Oregon. But it's important to think about because it's an interesting alternative. It's a really well-crafted, thoughtful alternative. It may be sort of the direction that the law is going. And if nothing else, it's a nice opportunity to think about what's wrong with the Guth versus Loft test. So let's think about, let's talk just briefly about the facts. The facts here are a whole lot simpler. The particular corporation at issue here is the Northeast Arbor Golf Club up in Maine. It is under the control, under the management of a chief executive named Nancy Harris, and she is the defendant in this case. The golf course is out in the country, surrounded by undeveloped real estate all around. And Ms. Harris was interested in this real estate as a commercial venture. And in fact, she was approached with offers to, with queries from a real estate broker looking for potential buyers. Here, the critical factual difference from Braz, and indeed it's a fact that would sink Ms. Harris under the ALI principles, is that she was in fact approached in her capacity as CEO of the country club. That is, the broker did not approach her with the idea that she might purchase this land for her own account, but rather that the club itself might be interested in buying this land. So the facts are a little more detailed than I'm going to make it out to be, but over the course of some period of time, Ms. Harris wound up purchasing not one but 2 different parcels nearby the golf course, I think abutting on the golf course, and with plans to develop them as residential real estate opportunities for her to sell to residential buyers. Presumably, she saw this as an opportunity for herself as a matter of business because, generally speaking, homes that are next to country clubs, homes that are right on the golf course, are quite desirable to some buyers, and there was money to be made. So over the course of some period of time, Ms. Harris bought 2 properties, and she and her children developed them commercially. Well, trouble arose because, of all things, a lawyer got on the board of directors of this country club. Some fella from D.C. who liked to go up and play golf, I guess on the weekends up in Maine, joined the board of the country club and decided that these purchases were undesirable from the country club's perspective and not consistent with Ms. Harris's duties. So an important fact is that Ms. Harris did in fact disclose these purchases. However, she only fully disclosed them after she had actually purchased the land, after the point at which it would be too late for the club to invest in them if in fact the club decided it wanted to. Moreover, some of her disclosures to the country club were incorrect and apparently deliberately false. She claimed that she wasn't interested in them and that she wasn't going to develop them commercially. All right, so at length, fiduciary litigation is brought against Mrs. Harris on the corporate opportunity theory. And here's where it gets pretty interesting. The court, starting on page 609, goes into an analysis of existing law and, of course, begins by discussing the Guth versus Loft test because that is the by far the majority test applied in jurisdictions. But the court points out, this is a nice example. The facts of this case are a nice example of what can often be wrong with the Guth test. If you think about it, the question under Guth in these circumstances would be, is the golf course interested in these residential real estate properties? Because those properties are in its own line of business. That is, the question would be, are these real estate properties commercial, financial investments that the golf course is in the business of taking and would desire to take? The answer to those questions is probably no, because the golf course, first of all, is not in the business of developing and selling real estate. Moreover, the golf course didn't have the money. The golf course probably could not have afforded these properties even if it did want to buy them. The thing is, Ms. Harris buying these properties was nevertheless still adverse to the corporation. And here's the idea. it was apparently of value, and the reason the dissident board member caused the trouble and brought this lawsuit, it was of value to the corporation to keep this land undeveloped. It's desirable to go play golf out in the undisturbed countryside, and it's a value to the corporation to keep that land undeveloped. So the corporation's own fiduciary was doing something contrary to the interests of the corporation, and that suggests that there's something wrong. There ought to be some sort of legal redress, and yet under the gut test, there probably wouldn't be. Okay, well, the court works through that, works through a couple of other tests that have been applied in various jurisdictions, and ultimately decides that none of the existing tests in force in any jurisdiction really suits the needs of the Maine Supreme Court. And that brings us then to this innovation that the Maine Supreme Court does in fact adopt, and that is Section 5.05 of the ALI principles. Okay, so not only are we rarely going to talk about state-by-state variations or minority rules, we're also rarely going to talk about statutory rules that appear outside either the Model Act or the Delaware Corporation Code, and this is one of those cases. So in fact, in our whole semester, we will only talk about 2 rules from the ALI principles. We've already talked about one. ALI principles section 4.01c was our statement of the business judgment rule, and this new section 5.05 is going to be an example for us of a minority approach to the business opportunity doctrine. Okay, so let's take a look at the text of this thing. Okay, so the main innovation of section 5.05 is that it attempts to take some of the subjectivity and guesswork out of applying this doctrine. And it does that in a couple of ways. So let's dig in. A chief thing to notice is that the real bulk of section 5.05 is broken down into 2 different sections, sections A and section B, and we really kind of need to begin with section B. So section B defines what is a corporate opportunity. So if an opportunity falls within the definitions that appear in section B, then they simply are corporate opportunities, and they have to be addressed under the procedures that appear in section A. If something is a corporate opportunity and the fiduciary fails to take steps required by section A, then the fiduciary has breached their duty of loyalty, case closed. So let's ask what constitutes a corporate opportunity. This is from section B. For purposes of this section, a corporate opportunity means any opportunity to engage in a business activity of which a director or a senior executive becomes aware either first in connection with the performance of their functions or under circumstances that should reasonably lead the director or senior executive to believe that the person offering the opportunity expects it to be offered to the corporation. Okay, so the very first fact under 5.05b is that if a senior executive or director of the corporation receives an opportunity in their official capacity, then it is a corporate opportunity. Case closed. No uncertainty left. The second opportunity, or the second possibility for definition of something as a corporate opportunity then appears under 5.05b1b. Something is a corporate opportunity if, in connection with the performance of functions as a duty, in connection with performance of functions as a director or senior executive, of which that person becomes aware either, and then this is B1b, through the use of corporate information or property, if the resulting opportunity is one that the director or senior executive should reasonably be expected to believe would be of interest to the corporation. So here is a different scenario that makes something automatically a corporate opportunity. If you learn of the thing because in your role as an executive or director, you used corporate resources, you used perhaps some secret information, or you used money, or you used some sort of research or something like that to find the opportunity, then it is a corporate opportunity, and you have to follow the procedures in subsection A. Okay, importantly then, subsection B2 says some other things can be corporate opportunities, but notice that subsection 2 only applies to senior executives and not directors. So any opportunity to engage in a business activity of which a senior executive becomes aware and knows is closely related to a business in which the corporation is engaged or expects to engage is a corporate opportunity. So the ALI principles here are being a little bit harder on senior executives than on directors. That is, a senior executive can be under an obligation to disclose things to the corporation under subsection A, even though it wasn't brought to them in their official capacity, and even though they didn't misuse corporate resources, so long as they know it's closely related to a business in which the corporation is engaged or expects to engage, they have to follow subsection B. So why are the principles harder on senior executives? Well, it's simple. The idea is that executives, unlike directors, are actually involved in the day-to-day management of the corporation. So they're more familiar with its business. They know more about what its investment plans are, and they can be held more accountable for being sure that they don't invest in things that the corporation itself might like. Okay, well, if you determine that something is a corporate opportunity under subsection B, then you have to turn to subsection A and determine what the fiduciary is supposed to do about it. So the general rule here is, basically, if something is a corporate opportunity, it has to be disclosed to the corporation, and the corporation has to take a pass on the opportunity before the fiduciary can invest. So let's take a little closer look. Generally speaking, a director or senior executive may not take advantage of a corporate opportunity unless one of three things is true. First, the director or senior executive first offers the corporate opportunity to the corporation and makes disclosure concerning the conflict of interest and the corporate opportunity. Then the next thing has to happen. The corporate opportunity is rejected by the corporation. And third, either the rejection of the opportunity is fair to the corporation, or the opportunity is rejected in advance following disclosure by disinterested directors, or, in the case of a senior executive, by their boss. Okay, so let's just go through that again. Once you know that something is a corporate opportunity, you as a director or senior executive must disclose it to the corporation, and your disclosure has to be full. You have to say what your conflict of interest is, and give all material facts relating to the opportunity itself. Then the corporation has to be rejected by the corporation. And that raises a small question of what has to happen in order for there to be a rejection, but for our purposes it basically means rejection either by the board or by some officer having sufficient authority to reject it on behalf of the corporation. And even after all of that, you have to show, you as the fiduciary have to show that the rejection was fair to the corporation. So what does that mean? Well, it means that the corporation has to have treated the thing appropriately. The corporation has to have had full information and given adequate consideration to the facts. So that it has to be fair. Notice, though, that even if the rejection isn't fair, the fiduciary might still be able to invest in the opportunity under subsection A3B. So 5.05A3B says, if the opportunity was offered to the corporation and rejected, and even though it wasn't fair under A3A, under B, if the opportunity is rejected in advance following disclosure by disinterested directors, or in the case of a senior executive, by a disinterested superior, in a manner that satisfies the standards of business judgment. So as long as the disinterested decision makers have rejected the thing and they did it on a reasonably informed basis, that's good enough. Finally, under 5.05A3C, so long as the opportunity has been offered and rejected by the corporation, and even if the rejection was not fair, the rejection was authorized in advance or ratified following disclosure by disinterested shareholders. Okay, so that was a lot of complex little intricacies, but the rule is simple enough, and it's kind of nice to see how the drafters attempted to deal with this. They made the identification of a corporate opportunity simple, and they identified things as corporate opportunities that probably very frequently corporations would not actually invest in. But nevertheless, the drafters of the principles decided that in those cases it probably makes most sense for us to require disclosures anyway, because disclosure isn't that hard, and let's just end the uncertainty. All right, so that's how that works. Okay, so there are some think about this questions in the text, and these will test us a little bit on both Bras versus CIS and on Harris. Let's turn to page 606 in the second edition. Think about this question. L is frankly kind of dumb. The test described in Bras is known as the line of business test. Is that accurate? I don't know. Question M. Suppose that at the time Bras acquired the Michigan 2 license, Price Cellular already had acquired a majority interest in CIS. Would that have made a difference in the analysis? So that's a very interesting question. And here's my answer. I think it would. Again, the question is, what if Price Cellular, in fact, got a hold of CIS? It got a majority interest in the company. It was a controlling shareholder. And it was still after the Michigan license, and Bras was after it too, but neither of them had acquired it. Well, in that case, it's really a whole lot more likely that Michigan 2 had become within the interest or expectancy of cellular information systems. And if Bras was still a director at that point, he owed a fiduciary duty to CIS to make the judgment whether the opportunity and fairness belonged to CIS and disclose it to CIS and ask CIS to reject before he invested. And that's all because Price Cellular now owns the company. Like Price Cellular, as the person calling the shots at CIS, is quite a lot more likely to be interested in that thing. And so Bras couldn't just take it without caution. All right, question N on the top of page 607. NITA is a director of Knight Corp, which owns and operates a chain of hotels. While so serving, she reads in a real estate ad that there is a hotel property for sale that would be of great interest to Knight Corp. NITA knows, however, that Knight does not currently have enough cash to buy it. She resigns from Knight Corp's board and then purchases the property for herself. Okay, so if this is, this is a question that follows Bras, so it's really asking us to apply the Guth test. There are facts here that support the idea that this would be a corporate opportunity. Knight Corp owns a chain of hotels. And in fact, the hotel that NITA wants to buy is of great interest to Knight Corp. So it's plainly in the line of business, and it is plainly in the interest or expectancy. She knows for a fact that Knight Corp is interested in this specific opportunity. There's a fact that would cut against this being a corporate opportunity, which is that Knight Corp is strapped for cash, probably can't buy this thing right now. I'm going to take a wild guess. It's a facts and circumstances inquiry. You never really know how these cases are going to come out. A person in NITA's situation would be kind of foolish to take this opportunity without disclosing it to the corporation. It's an easy enough thing to just go to the corporation and ask them to consider the opportunity and give you permission to buy it if they don't want to. Okay, but notice that there's actually a little trick in this question. We're told that she resigns her position and then purchases the property for herself. Okay, that raises actually an issue we really haven't talked about up to this point, a basic rule of fiduciary obligations, which is a person owes fiduciary duties only while they are a fiduciary. So if you're an agent, you owe fiduciary duties to your principal only up until that time that you're fired or you quit. Okay, there's some qualifications to that. There are some obligations that continue even after the duration of the agency, but generally speaking, the duties end as soon as your agency relationship ends. So as soon as NITA leaves this job, she can invest in the hotel. Okay, following the Harris case, there are a couple more questions. So on page 613 in the second edition, question O. Suppose that Miss Harris had purchased a piece of property adjoining the club's golf courses and had opened a meat packing plant on it. Would that present a corporate opportunity issue? I think really the question here is exactly the same as the facts of the case itself. It would be quite undesirable to the corporation if such a business were to pop up out there in the pristine woods in Maine. Whether, under the Guth test, probably this opportunity would not be within the interest or expectancy of the company, and she can do this even though it's quite hostile to the interests of the corporation. Under the new Maine test, though, it's actually kind of uncertain. I mean, the real question is, how did she learn of the opportunity? If she was approached in her role as CEO, well, it really doesn't matter what the purpose is that she intends to put the property to. If she owes it to the corporation to disclose and get a rejection. But I guess there are some facts we don't really know. And just to clarify, it doesn't matter under the Maine test um, if the business isn't in the interest or expectancy of the corporation, so long as it can be shown that the fiduciary either learns of the opportunity because of their capacity as fiduciary, or if they misuse corporate resources to identify the opportunity. A minor question would be, let's say it's in Maine. Ms. Harris learns of the real estate not because of either being contacted in her role as CEO or by virtue of misuse of corporate resources. We still know that under 5.05 B2, that a senior executive, which surely includes the CEO, can't engage in an opportunity for business activity that is closely related to a business in which the corporation expects to engage. Well, the corporation here isn't going to do a meatpacking plant. So I guess it's possible that this meatpacking thing could be a kind of circumstance that still falls through the loophole of Section 5.05. Okay, well, question P on page 613 is actually a question we've already answered. How would the Northeast Harbor versus Harris case likely have come out under Guth? And the answer is, well, probably the Mrs. Harris would get away with it because this opportunity just wasn't in the interest or expectancy of the golf club, and the same with the meatpacking hypothetical. Okay, so let's move on to some other the other piece of today's reading assignment, which is exculpation under various provisions for insurance and indemnification. Okay, so we've now actually covered most of what we're going to cover in the substantive law arising under the two basic fiduciary duties, which are the duty of care and the duty of loyalty. We still have some things to talk about that are ancillary or auxiliary to those basic rules, and that's what we're going to talk about a couple of those things now. And specifically, the topics for the rest of this lecture involve special situations in which corporations might try to protect their own fiduciaries against the risk that is posed to them by fiduciary liability in shareholder derivative actions. You might wonder, these are obligations that are owed to the corporation that are supposed to protect the corporation. Why would corporations be protecting their own fiduciaries, making it easier for their fiduciaries to take advantage of them? Well, the answers are a few. One is that corporations will all say that it's important to them to be able to attract talent, to be able to attract directors and officers of higher caliber, and they're all concerned that they won't be able to do that if those people are subject to liability risks. A little bit more cynically, one thing that definitely plays a role here is that, there is a sense, and this is sort of inescapably political, you can feel about it how you like. I'm not even sure how I feel about it. But there is a sense that these rules, these fiduciary duties, are enforced by and large by lawyers. Not so much by shareholders, but by lawyers who find the cases and then find shareholders to stand in as plaintiffs to bring them, and those lawyers work on a contingency basis. So there's some sense that this litigation is sometimes a little bit abusive. It's nuisance litigation. It's not really brought in the best interest of the corporation. And so corporations very frequently try to protect their own fiduciaries from these risks. Okay, so it turns out that there are quite a number of ways that corporations can protect their fiduciaries. And we need to distinguish amongst them. We're going to distinguish between three of them specifically. First, corporations can give their fiduciaries insurance, literally meaning that they can just go out and buy insurance policies. The corporation can purchase and pay the premiums on insurance policies that will protect the fiduciary and pay damages claims if they're found liable in a lawsuit. Second, corporations can engage in what we call indemnification. And this is kind of importantly different. Indemnification does in fact differ from insurance because indemnification is a choice by the corporation to pay its own money to the fiduciary to reimburse the fiduciary for injuries that are suffered in the course of the fiduciary doing their job, including getting sued and perhaps paying damages for lawsuits for conduct they undertook in their official role. We got some statutory law that actually puts some real limits on the ability of corporations to indemnify their fiduciaries. And the final thing we'll talk about is exculpation, which differs from both insurance and indemnification. Exculpation literally means a choice by a corporation to change the liability rules under which its fiduciaries operate, to make it harder to sue them as a matter of substantive law, and we'll get to that. Okay, so let's start with insurance, and to think about this, we're going to look at one subsection of a provision of the Delaware Corporation Code, 8 Delaware General Corporation Law, Section 145G. So let's take a look. Okay, so as for insurance, the main thing to notice is that the law is just extremely permissive. So a corporation can purchase insurance for its fiduciaries under virtually any circumstances. And the important thing here is that at the end of 145G, the code says a corporation can purchase insurance even in circumstances in which the corporation would not be permitted as a matter of law to indemnify the fiduciary. So it's interesting to us to ask, well, when does the law prohibit actual indemnification, meaning payment of the corporation's own funds to the fiduciary? And to figure that out, we're going to take a look at other provisions of Section 145, specifically Section 145, subsections A through C. Okay, so the thing about 145A through C is that even though this is pretty dense and sort of more complex than you probably give it credit for when you first look at it, what you need to get out of it is actually fairly straightforward. Okay, but we've got to unpack quite a lot of detailed intricacy here. So first, and crucially, you have to understand that sections A and B deal with two different scenarios. So let's dig through this a little bit. Section 145A. A corporation shall have power to indemnify any person who was or is a party to any action, suit, or proceeding other than an action by or in right of the corporation by reason of the fact that the person was a director, officer, employee, or agent of the corporation. All right, so what does that mean? Section 145A deals with cases that are other than an action by or in right of the corporation. Well, let's put that on the shelf just for 1 second and look at subsection B. Subsection B says that a corporation shall have power to indemnify any person who was or is a party to any action or suit by or in right of the corporation by reason of the fact that the person was a director, officer, employee, or agent of the corporation. Okay, so the distinction between A and B is that A deals with those liabilities that arise in lawsuits against the fiduciary that are other than actions by or in right of the corporation, and subsection B deals with those lawsuits that are actions by or in right of the corporation. So what does that mean? Well, by or in right of the corporation means derivative cases, right? Cases in which a shareholder plaintiff, a person who is not actually the corporation itself, brings a lawsuit based on rights that actually belong to the corporation. So that basically means shareholder derivative actions. So subsection B says a corporation is empowered to indemnify a fiduciary for liabilities or risks that arise in derivative litigation. Subsection A deals with everything else. Okay, so subsection B, if it deals with derivative litigation, well, what does that mean? Essentially, that means essentially subsection B deals with claims for breach of fiduciary duty. Actions by or in right of the corporation are ordinarily claims for breach of fiduciary duty. That's what shareholder derivative plaintiffs sue for. It's not actually true that those are the only things that shareholder derivative plaintiffs can assert. Technically, a shareholder can assert any right of the corporation. So, for example, a shareholder could bring a lawsuit on behalf of the corporation for breach of contract. If the corporation, for whatever reason, is choosing not to enforce a contract against someone, a shareholder could enforce that contract derivatively. Okay, but that's not really the bulk of it. The meat of actions by or in right of the corporation are lawsuits for breach of fiduciary duty. The lawsuits that appear under subsection A then are everything else. So all the other reasons that a person could get sued for acting as an officer, director, employee, or agent of a corporation. You might engage in conduct that violates the federal securities laws, the federal environmental laws, OSHA, employment protections, et cetera, et cetera, et cetera. If you get sued for any one of those things, and it can be said that you're being sued because, by reason of the fact that you were a director, officer, employee, or agent, then you may be entitled to indemnification under subsection A. Okay, so how do these two things differ? Well, under subsection A, if it's not a derivative case, if it's not a fiduciary duty claim, we're told that the person can be indemnified by the corporation against, and here I'm quoting from the middle of that paragraph, against expenses, including attorney's fees, judgments, fines, and amounts paid in settlement actually and reasonably incurred by the person. So what does that mean? Well, that means you can actually be indemnified even for fines and judgments. All right, so in other words, even if you're guilty, you can get reimbursed by the corporation. Even if you did something bad, you got fined by the government or somebody sued you successfully for damages, well, the corporation can, in fact, indemnify you. Subsection B is a little bit different. In the middle of that paragraph, we're told that for liabilities arising in lawsuits by or in right of the corporation, you can be indemnified against expenses, including attorney's fees, actually and reasonably incurred by the person in connection with the defense or settlement of such action or suit, if the person acted in good faith and in a manner reasonably believed to be or not opposed to be the best interest of the corporation, except that no indemnification shall be made in respect of any claim as to which such person shall have been adjudged to be liable to the corporation. Okay, so the crucial difference between paragraphs A and B is that under B, if you've been sued by a shareholder derivative plaintiff, you cannot be indemnified if you're found guilty. All right, and you can't be indemnified for anything. We're told that no indemnification shall be made in respect of a claim in which you lose. And that's really very simple, because if the action is by or in right of the corporation, that means you've breached a right, breached an obligation that you owe directly to the corporation. So it would be kind of ridiculous to make the corporation then indemnify you for your own attorney's fees and expenses. All right. One last thing to note about subsections A and B is that both of them include the following language. Even in cases where you otherwise could be indemnified, it must be true that you acted in good faith and in a manner that you reasonably believe to be in or not opposed to the best interests of the corporation. So you can't act in bad faith. You can't deliberately do things that are harmful to the corporation and expect to be indemnified. Finally, under subsection A, we're told that with respect to any criminal action or proceeding, you cannot have reasonable cause to believe that your conduct was unlawful. Okay, so under subsection A, you can in fact be reimbursed by the corporation even if you lose the case. But if it's a criminal case and you had reason to believe that you were engaged in unlawful conduct, then you cannot be indemnified by the corporation. All right, the final thing we need to talk about is subsection C of 145. So let's take a look at that. Okay, so 145C is again a provision that's maybe a little more complicated than it initially seems, and it does something kind of interesting. 145C says, to the extent that a present or former director or officer of a corporation has been successful on the merits or otherwise in defense of any action described in subsections A or B, then such person shall be indemnified. So what is this saying? Well, it's saying that in certain circumstances, certain people who actually win their cases must be indemnified by the corporation. So first of all, this is telling us that in all other cases, for example, where the person loses, indemnification is not mandatory. But if the person is successful on the merits or otherwise, indemnification is mandatory. Okay, so notice one little curly Q there. 145C actually only applies to directors or officers, present or former directors or officers. So employees or agents don't get mandatory indemnification under the law, only officers and directors. Alrighty, so that actually brings us to a nice, useful little set of think about this questions on page 644. So let's take a look at those. Okay, so these questions are really going to help us work through the intricacies of those sections 145A through C. So question A, DCA Incorporated, the Delaware Corporation, has a provision in its Articles of Incorporation providing for indemnification to the fullest extent provided by the law. Okay, that's important because that means that the corporation does in fact have to indemnify a fiduciary up to whatever amount of indemnification would be permissible under 145A. In other words, it's not mandatory to indemnify them as a consequence of 145C under these circumstances, because this corporation has gone even farther. It said, even when indemnification wouldn't be mandatory under 145C, we will provide in our articles that we will in fact mandatorily indemnify our fiduciaries to the fullest extent that would be permitted under 145A and 145B, even in situations that wouldn't involve mandatory indemnification. All right, well, moving on. DCA's directors are sued derivatively for violating the duty of loyalty by reason of their total failure to supervise DCA's employees, notwithstanding red flags that would have put them on notice that embezzlement was taking place. The directors lose and seek indemnification for the amount of damages owed plus costs. Must DCA pay? The answer here is quite plainly no. DCA must not pay because indemnification would not be even permissible under these circumstances. Why is that? Well, really for two reasons. First of all, we have to ask, what kind of lawsuit is this? We're told that the directors are sued derivatively for violating their duty of loyalty. That means that they have been sued by or in right of the corporation, and therefore this is a 145B case. 145B tells us that indemnification is not even permissible when the directors lose. Another reason they would lose, they would not be entitled to indemnification even if this were a case in which they won. It turns out they acted in bad faith. So even if they won the case, the directors were sued derivatively by reason of their total failure to supervise DCA's employees, notwithstanding red flags that would have put them on notice that embezzlement was taking place. Remember when we talked about a case called In Re Caremark? In Re Caremark was a case that was about corporate directors' failure to monitor their employees. And we were told that if the failure to monitor, the failure to set up reasonable information systems is so graphically bad that it constitutes a total failure to supervise, then that's conduct that's actually in breach of the duty of good faith. It's not even in good faith. So even if they had won their duty of loyalty case, under Section 145B, we're told that there can't be indemnification for conduct that, quote, if the person did not act in good faith and in a manner that the person reasonably believed to be in or not opposed to the best interest of the corporation. So indemnification is not permissible under question A. Okay, question B, very similar. DCB Incorporated. A Delaware corporation has a provision in its articles providing for indemnification to the fullest extent permitted by law. So again, any indemnification that would be even permitted is mandatory for this corporation. Its directors are sued derivatively for violating the duty of loyalty by reason of their total failure to supervise DCB's employees, notwithstanding red flags that would put them on notice. Okay, so again, we've got the problem that they're sued under 145B, which may be a problem if they lose. If they lose, they can't be indemnified at all. Moreover, they've acted in bad faith, so they can't be indemnified. The directors here win and seek indemnification. Must DCB pay? Again, I think the answer is no. Their total failure to take any supervisory action, notwithstanding red flags, is action in bad faith. All right, question C. A lot going on in this one. DCC Incorporated, a Delaware corporation, has a provision in its articles providing for full indemnification as permitted by law. Directors are sued derivatively for loyalty violation. Again, there's a total failure to supervise employees, notwithstanding red flags. The matter is settled at 50% of the amount claimed, and the directors seek indemnification for the amount of settlement plus the cost of their defenses. Okay, so this is interesting because this now implicates an issue within 145C. Ordinarily, 145C makes indemnification mandatory if the fiduciary is successful, quote, successful on the merits or otherwise. And the thing is, settlement can be successful on the merits or otherwise. The problem here would be that the fiduciary settled for actually some damages. So they agreed to pay some of the damages charged, and the courts have said that is not successful on the merits or otherwise. Turns out there's a whole bunch of other reasons they couldn't be indemnified. It wouldn't even be permissible under law because, again, they acted in bad faith. There was a total failure to supervise subordinates, notwithstanding red flags. Right? Question D. DCD Incorporated. A Delaware corporation has a provision provided for indemnification to the extent permitted by law. Here we have this wrinkle. The directors are sued by shareholders who purchased their shares in an offering involving defective disclosure documents. Federal securities laws provides that a company's directors are liable in such a situation unless they can prove that they acted reasonably. Okay, so here the wrinkle is that it appears that we're no longer in, this case no longer falls under Section 145B. This is not a lawsuit by or in right of the corporation. Rather, these shareholders are suing in their own personal capacities for violation of the federal securities laws. They believe they were sold securities with defective disclosure documents. So now it's 145A territory. Okay, moving on. Federal securities law provides that a company's directors are liable in such a situation unless they prove that they acted reasonably. DCD's directors fail to establish their defense and seek indemnification for the amount of damages owed, plus the cost of their unsuccessful defense. Okay, well, they were not successful on the merits or otherwise, right? So indemnification would not be mandatory under Section 145C. However, this is, again, a case in which the corporation has a provision in its articles saying it will mandatorily indemnify directors up to whatever extent is permitted by law. So you might say, well, it's 145A, and therefore, even though they lost, they could be permissibly indemnified. Here there is a little wrinkle, though, which is a little bit uncertain. We're told that they could have made out this defense showing that they acted reasonably, and they failed to do that. So their disclosure failures here weren't even reasonable. And there are a couple of reasons that maybe indemnification wouldn't be permitted under Section 145A. First of all, if they didn't act even reasonably, perhaps they acted in bad faith. Second, you wonder, could they have acted in a manner that they reasonably believed to be in or not opposed to the best interest of the corporation if they failed to make even reasonable disclosures? So here it's not exactly clear what would happen, but it seems like they may not be indemnifiable because even under Section 145A. Okay, here we have exactly the same facts as question D, except that in this case, the directors do in fact make out the defense showing that they acted reasonably, and the question is, must the corporation pay the cost of their defense? You might notice that this question asks only must it pay the cost of their defense. That's because they actually won the case, so there were no fines or penalties, and the only expenses to be reimbursed would be attorney's fees and costs. And the answer is yes. The answer would be yes, even if the company didn't have the articles provision saying that it would provide all permissible indemnification, because here the directors were successful on the merits or otherwise, and so indemnification would be mandatory even under Section 145C. All right, same facts again, except here the defendants aren't actually successful on the merits or otherwise. We're told that the matter is settled at 50% of the amount claimed, and the directors seek indemnification for the amount of the settlement plus cost of their defense. Must DCF pay? You might think the answer is no, because they lost and they were not successful on the merits or otherwise. But remember, the corporation has an articles provision saying it will indemnify up to the fullest permitted extent. And here, because this is not an action by or in right of the corporation, it's a Section 145A case. And even though they've admitted to some liability, it doesn't matter. The corporation is permitted to indemnify them, and because it's provided in its articles that it will, then it must. Okay, and finally, question G asks us, what would have happened in each of the prior cases if the company didn't have a mandatory indemnification provision saying that it would indemnify up to the extent permitted by law? And the answer is that the company would only have to pay in cases in which the defendants were in fact successful on the merits or otherwise, and they could be indemnified under the terms of the 145A or 145B. Okay, so we have to ask, where were the defendants successful on the merits or otherwise? And the answer is only in B and E. In every other case, they either lost or they settled. And so there wouldn't be mandatory indemnification under 145C except under questions B and E. And in fact, it appears they wouldn't be indemnifiable under question B because they appear to have acted in bad faith. Okay, so something that might be a little bit misleading about those think about this questions is that it seemed like in most of the cases the defendants were losing. In fact, they only stood on really two strong legs in question E, where they won and there was no utter failure to supervise employees, etc. That's a little bit misleading. Actually, indemnification is not that hard to get in most circumstances, at least where the defendants win their case, and oftentimes even when they don't. What's artificial about the questions is that we threw in this little wrinkle that in most of the cases the defendants totally failed to supervise their employees, notwithstanding red flags. So that's pretty unusual. Evidence of bad faith is pretty unusual. Okay, so that brings us to some cases that will tease out these issues a little bit further. I'm going to try to go through these kind of quickly because this is getting to be a long lecture already. So let's talk about the Waltuck case. So Waltuck versus Conti Commodity Services on page 646 involves a case in which a fella, this Norman Waltuck, got his corporation in a whole bunch of trouble. He was a commodities trader at a big commodity brokerage house, Conti Commodity Services, and in that role, he engaged in some sharp practices. He cornered the market in silver, and it was a strategy to get himself very rich. Unfortunately, it also turned out to be illegal, and it caused a lot of people to lose a lot of money. So there were lots of lawsuits against Conti Commodity, as well as a federal law enforcement action by the Commodities Future Trading Commission Corporation. Okay, so Waltuck was let go. He caused a lot of trouble. Conti Commodity fired him. But then a couple things happened. First of all, Waltuck himself was sued by the Commodities Futures Trading Corporation, and he agreed to take some penalties, including a ban on his own trading activities. The other thing that happened was that several private lawsuits were filed against Conti Commodity. In those lawsuits, Conti Commodity was not the only defendant. A number of its own executives and other staffers, including Waltuck, were named as defendants. Conti Commodity managed the litigation of all those cases, and it settled with those private plaintiffs. And while Conti Commodity itself paid money to those plaintiffs, Conti Commodity also agreed to a release in which the plaintiffs agreed to let all the individual defendants off without payment of any money and without admission of liability. So the question in the case was whether Waltuck could seek indemnification from Conti Commodity. Now, Conti Commodity does not have the kind of provision in its articles like we saw in the Think About This questions, saying that the company agrees to indemnify its fiduciaries up to the fullest extent permitted by the law, even if indemnification would not be mandatory under Section 145C. So the only question in the case, now just to be clear, Waltuck here is suing his old employer, and the only question in the case is whether the company is required to give him indemnification because it doesn't want to under Section 145C. So in other words, the legal question in this case is whether in any of the liabilities he suffered, if they were actions that were permissibly indemnifiable under Sections 145A or B, the legal question then becomes whether Waltuck was successful on the merits or otherwise in either of those cases, and if he was, indemnification is mandatory under Section 145C. And the answer is he was successful in one of them, but not the other. So in the CFTC case, even though he didn't pay any money, he agreed to a settlement in which he admitted liability, and he took some penalties. He agreed to a ban on trading and some other penalties for a while. The more interesting case is the settlement. So Conti Commodity, again, settles a case against private plaintiffs, and in so doing, it pays some money. So Conti Commodity itself definitely was not successful on the merits or otherwise. It agreed to liability and it paid out money. But it also negotiated a release of liabilities against a bunch of individuals, including Waltuck. And the question for the court was, could it be said that Waltuck was successful on the merits or otherwise when no court actually reached the question of whether he was liable or not? And the court's answer is pretty interesting here. The Second Circuit's answer is essentially a policy answer. The court says, um, yeah, he was successful. I mean, for one thing, the language of the statute says that you have to be successful on the merits or otherwise. So it can't be that the only way that you can be successful under Section 145C is to actually have litigation on the merits and be vindicated at trial, or else the words "or otherwise" would be superfluous. But also, there's a policy reason. If one had to go through a full merits trial and be vindicated on the merits, that would discourage the use of various kinds of arguments, like statute of limitations arguments, um, uh, jurisdictional arguments, other bases for seeking dismissal that wouldn't actually reach the merits, and the courts don't like that kind of thing. So success on the merits or otherwise, it surely includes winning at trial, going to trial on the merits and winning, but it can also mean winning in other ways. Probably the one thing that it doesn't mean is a settlement in which you actually admit liability or agree to some sort of penalty in damages or injunction or otherwise. Okay, so there's a think about this question on the bottom of page 648, following up with the prior questions. Question H. DCH Incorporated, a Delaware corporation, has a provision in its articles providing for full indemnification as permitted. DCH and its president are sued by the federal government as, quote, operators of a polluting facility. So let's ask, what kind of action is that? Well, it's not by or in right of the corporation. This is an action on behalf of the federal government, so it's Section 145A. The claims ultimately are dropped because of the statute of limitations. The president seeks indemnification for the cost of his defense. Must DCH pay? The answer plainly is yes. He was not successful on the merits, but he was successful otherwise. There's no admission of liability, and there's no payment of any sort of damages or any other penalty. Okay, so that brings us to another case, Heffernan versus Pacific Dunlop GNB Corporation. This one's just a little bit more complicated, so let's take a look at a diagram. All right, so the Heffernan case is pretty straightforward, but a little bit more complicated. Heffernan is an individual who was a shareholder and a director of two different companies. One company was the parent corporation of the other. The parent was a holding company. The subsidiary was an operating firm. The parent corporation owned a controlling share of the subsidiary, but a minority of shares were held in the subsidiary by outside parties. So Heffernan was one of those. So Heffernan and a group of other control persons of GNB Holdings and GNB desired to sell the firm. At length they negotiated a sale of the firm to an outside party named Pacific Dunlop. An interesting fact, a wrinkle here, is that unlike the Waltuck case, GNB Holdings and GNB both had articles, provisions providing that they would in fact indemnify directors to the fullest extent permitted by Delaware law, even if indemnification would not have been mandatory under Section 145C. So in the course of this negotiation, Heffernan and other defendants involved with GNB provided Pacific Dunlop with some information that turned out to be misleading. And in particular, they failed to disclose certain risks under the federal environmental laws that wound up causing Dunlop to have a less valuable investment than it thought it was getting. So Dunlop was actually successful in bringing a lawsuit against Heffernan and some others to recover for its injuries. It sued under a federal statute that actually provides for rescission of security sales when misleading statements have been made in the sale of those securities. That said, Pacific Dunlop did in fact acquire GNB. And so something a little bit funny is happening here. Heffernan wants indemnification from GNB, and GNB really kind of uniquely does not want to provide indemnification under the circumstances because GNB is in fact Pacific Dunlop. Pacific Dunlop acquired this firm, then successfully sued Heffernan, and is now being asked to compensate Heffernan for his losses from that suit. So if GNB compensates him, Pacific Dunlop is in effect just giving him back the value that it acquired when it successfully sued him. So a bit of an unexpected stinger for Pacific Dunlop. Anyway, the legal question is an interesting one. Heffernan was not successful on the merits or otherwise. So the question is whether he's indemnifiable at all under Section 145A. And this boils down, it's a 145A case, by the way, because this claim is not buyer in right of the corporation. It's not buyer in right of GNB. Nobody's suing Heffernan on a theory that he breached its fiduciary duties to GNB. Rather, Pacific is suing for its own personal injuries caused by Heffernan. The question, though, is whether GNB even can indemnify Heffernan for these injuries, because it seems like the basis of, and this is certainly what Pacific Dunlap says, it seems like the basis of Heffernan's injuries don't actually have to do with his official capacities as a fiduciary of GNB. So in other words, it seems like he is not being sued, quote, by reason of the fact that he was an officer, director, employee, or agent of GNB Holdings. So the question for the court is whether that's true. And the bottom line is the court interprets that language very broadly. And in this particular case, the court says, well, this was by reason of the fact of his employment there, even though the lawsuit is based on his sale of his own personal property, because the gravamen of the lawsuit is that Pacific was injured when control group persons within GNB orchestrated a transaction relating to the sale of GNB that injured Pacific Dunlap. And Heffernan's part in that, even though it was a sale of his own personal property, was sort of inextricably entwined with his role as a director. And one important little point the court noticed was the whole theory under which Heffernan was responsible for this injury to Pacific was that he failed to disclose facts to Pacific that would have been useful to it in deciding whether or not to purchase these shares. But he could only have known those facts because he was an insider to the corporation. So Heffernan's role was, as a director, was sort of integral to his liability here. So even though, strictly speaking, the lawsuit related to his own personal conduct and involved his own personal property rather than his official duties, it was closely enough linked to his role in the corporation to be, quote, by reason of the fact of his job there. Okay, and so finally we turn to the last topic for this long lecture of material, and that is a set of legal rules that take a somewhat different approach to protecting fiduciaries, different, that is, than providing them with insurance or indemnification, and that is exculpation. So the difference here is, instead of reimbursing fiduciaries for injuries they incur as a result of fiduciary obligations, it's just to limit or take away the obligations entirely. So this has actually come up before. We've mentioned a few times that Delaware and many other states have modified fiduciary obligations just to protect their fiduciaries from them. And the most important example of doing that is Delaware's own 8 Delaware Code Section 102B7. We'll talk about this in detail, and we'll talk about the case, a case in which it is dealt with. Let me mention that there is an exact, essentially verbatim version of 102B7 contained in the Model Business Corporation Act, and it is Section 2.02B4. So 102B7 works just like Section 2.02B4 in the following sense, and I mention this because we've actually talked about Section 2.02 before. Remember that Model Act Section 2.02 was a basic provision governing how corporations are formed in the beginning, and in particular, Section 2.02 specifies items that must be included in the Articles of Incorporation when the corporation is formed, and several other items that can be added if the incorporators like. Section 102 of the Delaware Corporate Code works in exactly the same way. It begins by stating certain provisions that have to be included in the Articles of Incorporation, and then lists others that may be included. So just like 2.02, subsection A of Section 102 states mandatory provisions. Subsection B lists several permissive provisions that a corporation can include if they like. 2.02 is just like that. 2.02A has mandatory provisions. Subsection B has permissive. provision. So both codes then in that subsection B include several things that are permissive, among them being an exculpation clause. And the two clauses are similar. So 102b7 and 2.024 are very similar. So let's we'll take a look at the Delaware Code provision instead of 2.024, in part just because 102b7 is the statute that's at issue in the case we're going to talk about, which is Arnold versus Society for Savings on page 653. Another reason to talk about the Delaware statute, though, is the Delaware statute was uncommonly important in the world for the following reason. Remember again the famous and significant case from Delaware of Smith versus Van Gorcum. Smith versus Van Gorcum was the merger case where Mr. Van Gorcum went off and negotiated, without giving it much thought, a merger deal with J. Pritzker. And Pritzker bought the company, but neither Van Gorcum nor anybody else actually gave any real thought to what the target corporation was worth. The rule that the Delaware Supreme Court announced was very significant because the court said, notwithstanding the business judgment rule, the ordinary protection of the business judgment rule, which effectively says that fiduciaries cannot be liable for the substance of their business decisions, won't actually protect them unless they took reasonable steps to inform themselves concerning the subject of their decision. And the fiduciaries in Smith versus Van Gorcum seemed not to do that. They were lackadaisical. They didn't even ask certain basic questions. Well, this caused a lot of consternation. It sent alarm bells off throughout corporate America, and Delaware reacted very quickly. Delaware's legislature adopted Section 102b7, and then other legislatures followed quickly, and so did the drafters of the Model Act in Section 2.02b4. So let's take a look at the details of 102b7. The details are trickier than they seem, so let's take a look. Okay, so you'll see that 102B, Section 102, subsection B, begins by saying that in addition to matters that are required to be in the certificate of incorporation, you can include any of the following matters. Subsection B7 then says that among the permissive matters can be a provision eliminating or limiting the personal liability of a director of a corporation or its stockholders for money to the corporation or its stockholders for money damages for breach of fiduciary duty. Okay, so that seems very broad, but already we can see that there are some significant limitations. First of all, notice to whom this applies. Ask yourself who can actually take advantage of this protection. The answer is, well, it's only directors. So officers can't be protected by this thing. Directors can, though. Notice, too, I mean, this may seem obvious, but it's worth saying out loud. This thing actually only applies if the corporation adopts it, right? 102b7 doesn't say this protection applies to all corporations. It says that if they so choose, corporations can, in fact, provide this protection. Okay, well, then follows a series of nitpicky little exclusions, which seem like they're sort of red tape administrivia, hard to pay attention to, but it turns out that in combination, they amount to a significant exception from the protection that can actually be applied. So let's look at them. We're told that a corporation, if it so chooses, can adopt this protection for directors, provided, however, that such provision shall not eliminate or limit the liability of a director for any of the following. For breach of the director's duty of loyalty to the corporation. Okay, so that's kind of big. So right off the bat, we're only talking about duty of care cases. Next, for acts or omissions not in good faith or which involve intentional misconduct or knowing violation of the law. Again, pretty significant limitations. Knowing violation of the law is pretty clear. You can't commit crimes and be protected from liability for injuries caused to the corporation. Intentional misconduct also seems pretty clear. If you deliberately did something that caused the company harm, well, that probably is an obvious exception from an exculpation provision. The big and easy to miss fact here, though, exclusion here, is for acts or omissions not in good faith. Remember, we learned when we talked about the In re Caremark case that if a director takes action that utterly fails to observe basic obligations, for example, if a person utterly fails to supervise subordinates, notwithstanding red flags, the courts have said that is action not in good faith. Okay, if you do something like that, it cannot be protected by an exculpation clause. Next, exculpation clauses cannot be used for conduct that would create liability under Section 174 of this title. That relates to declarations of dividends under improper circumstances, so we won't talk about that. But then finally, you can't use exculpation clause protection from a transaction from which the director derived an improper personal benefit. I'm not exactly sure when it would be the case that that would apply, even though there hasn't been a violation of the duty of loyalty, but it seems possible. Okay, so the basic lesson then of 102b7, it seems like a very broad exculpation possibility, but actually it can be understood to be relatively narrow. In effect, and by the way, there's one other exclusion from this thing that we didn't talk about. 102b7 says you can have this provision protecting directors from liability, but only from one specific kind of liability. So in the beginning of that little paragraph, you can have a provision eliminating or limiting the personal liability of a director for monetary damages. Okay, so in other words, this doesn't apply to the other kind of damages, which are injunctive. So 102b7 then boils down to basically one carve out from what would otherwise be the director's liability exposure. Directors can be protected from money damages causes of action for breach of care violations, so long as there was no conflict of interest, the director acted in good faith, there was no intentional misconduct or knowing violation of the law, there wasn't a dividends violation, and there was no improper personal benefit. Okay, so that's what we're talking about in Arnold versus Society of Savings. Let me suggest one last thing. The adoption of 102b7 in Delaware and similar provisions in the Model Code and many other jurisdictions had an effect on fiduciary litigation. Because you can't get money damages if all you're looking for is a garden variety duty of care claim, plaintiff lawyers stopped filing them. So duty of care litigation is largely dead because most corporations have in fact adopted exculpation clauses of this nature. And now the whole game for plaintiffs' lawyers is to find ways to challenge conduct and allege either that there was a conflict of interest or that there was some other conduct that would be accepted from 102b7, like actions in bad faith, which effectively means total failure to supervise, or a knowing action of misconduct or in violation of law, or whatever. And so that's exactly what happened in Arnold versus Society for Savings. I don't really want to talk about the facts of the case because they're kind of complicated, but it was basically one more merger transaction. We give some details of how the transaction was set up, but it's not worth even digging through because it's so complicated. Basically, you've got shareholders bringing fiduciary litigation against the board of a target corporation that was merged into another company for breach of fiduciary duty. And you see here the efforts that plaintiffs go through to try to claim that whatever challenged conduct it was involved either some conflict of interest or some other conduct not within 102b7. And you see the typical reaction of a court to those kind of claims, which is to say, go fly a kite. That is, the court says, no, what you're really challenging here in substance is just the substantive judgment of these defendants as to a business decision. You haven't described anything about the decision that would constitute conflict of interest or breach of the duty of good faith, and so go pound sand. Okay. All right, so that brings us to one last thing for this lecture, and that is one last little idea, one kind of surprising, remarkable reaction that one other legislature had to Smith versus Van Gorkum, and that is the fairly extravagant rule contained in the Virginia Code on the duty of care. So on page 655, we reprint in the bottom right-hand corner provision of the Virginia Corporation Code that modified the duty of care. And this, again, was in reaction to Van Gorkum. At first, when you look at this, it may not seem like it's such a big deal. It's not even clear how it differs from 102b7. It's not even clear how it really differs from the business judgment rule. But in fact, it differs quite a lot. So let's take a look at that. It's in your book, but I made a little diagram. I made a little picture of it so we can look at the words, and let's take a look. Here it is. Alrighty, so here it is. Looks short, looks harmless. It's more than it appears, though. A director shall discharge his duties as director, including his duties as member of a committee, in accordance with his good faith business judgment in the best interest of the corporation. What does this take out of the business judgment rule after Van Gorkum? Well, a couple things. First of all, you might stop and say, notice that there is no word rational in there. There's no obligation that the motives of the person making the decision have to be even rationally related to the best interests of the company. That may not matter that much. It only excuses directors from cases like perhaps Litwin versus Allen. Remember, that was the case involving the bond deal in which the company literally, logically could not benefit. All right, so that's probably not a big exclusion. But what else we got here? Well, the big thing, and it's not coincidental that this was in reaction to Smith versus Van Gorkum, is that there's no obligation to be even reasonably informed. You don't have to do any work at all as a director in Virginia to make sure that you're making the right decision. You just have to make the decision. So if you stop and think about it, this is basically the attitude that was contained in the dissent in Smith versus Van Gorkum. In that case, the dissenters said, look, we just shouldn't be in the business, we courts, of asking whether directors have reasonably informed themselves about their decisions. And in Van Gorkum itself, for example, the directors were all very fancy people. One of them was the dean of the Harvard Business School, as I recall. Others were prominent, very experienced business leaders, and the dissent said we shouldn't be second-guessing these kinds of people as to how they make business decisions. So that's basically what Virginia said. We're just not going to let our courts second-guess the decisions of people who've been appointed as directors. The shareholders take the risk that those people will be appointed who are competent and reliable. So all that is required in Virginia is to show that you made a decision in good faith, no matter how bad it was. One other thing to observe is that there are a couple of other differences between this thing and Delaware 102b7. First of all, you'll notice that a corporation doesn't actually have to adopt this. That is, it doesn't matter what the Articles of Incorporation says. The statute itself says it shall be the standard that no one can be held responsible as a director for their substantive business decisions, even if they were irrational, even if they weren't reasonably informed. Second, this applies to all liability, that is, all remedies. So in other words, it doesn't matter if the plaintiff is asking for money damages or injunctive relief. The cause of action is just done away with. So we get cases like WLR Foods versus Tyson Foods. And again, the facts aren't really worth dwelling on too much. The basic lesson is that there is an ordinary fiduciary duty cause of action in this case, and the court says these plaintiffs haven't demonstrated anything. Yeah, that's my three-legged dog, Max, going out of his mind. Sorry. The court says there's just no evidence here of anything that could rise to the level of a breach of good faith, and therefore there's no liability. All right, we get two questions following WLR, so let's take a look. Here's question I on page 657. Question I. The directors of Chicken Incorporated, a Virginia corporation, have for several days debated the merits of permitting the company to be acquired by Poultry Co. for a price of $25 per share. The board was fully informed itself by, among other things, consulting with lawyers and investment bankers. Sounds good. According to the investment bankers, $25 is within a range of fairness. The board is evenly divided, however, and ultimately decides the matter by flipping a coin. Has the board breached any duty for which it might be liable in monetary damages? I seriously doubt it. Remember, this is a Virginia corporation. The only question is whether they took action in good faith. Can't even inquire into the reasonableness of the way that they informed themselves or made their decisions. So question J then follows up and asks, how would it be different if this were a Delaware corporation which had adopted 102b7? The difference is this looks a little bit more like a decision made that wasn't reasonably informed or wasn't rationally related to the best interest of the company. I'm not sure that plaintiffs would win even in Delaware if the board fully informed itself, debated, came to a draw, and then decided by flipping a coin. I'm not sure that plaintiffs necessarily would win even in Delaware. But let's notice that even if they did, the consequence of the corporation having adopted a 102b7 exculpation clause is that there won't be money damages, and that's it. Okay. All right, so that was a long lecture. I hope you're hanging in there. Again, I wish we didn't have to do this by video. I hope this is working out for you. If it's not, I want to know. I want to hear how we can make this better. If this is working for you, that's good for me to know too, but you don't have to make me feel good. All I want to know is whether this is serving our educational needs as well as we can do. And that's it for today. Okay, see you next time. Hang in there.